Andrew Branca is a foremost expert on U.S. self-defense law across all 50 states. His expertise has been used by the Wall Street Journal, Chicago Tribune, NPR, numerous other media organizations, and by private, state, and federal agencies. He's a Massachusetts lawyer. He's a life member of the NRA. Well, we all have that problem occasionally. And an adjunct professor on the law of self-defense at Sig Sauer Academy in Epping, New Hampshire. He lectures and speaks throughout the country on how to protect yourself against both an attack and the legal machine afterward. He's a masterclass IDPA competitor, NRA certified firearms instructor. He holds numerous concealed handgun permits from what I can see here. And his book, The Law of Self-Defense, was recently reviewed in the NRA's First Freedom magazine, which had to say, and I quote, "Since most gun owners are so law-abiding that they have no personal experience with the criminal justice process, Branca gives an overview of the crimes that may be charged in a self-defense case, including what to expect from an investigative and judicial process in which none of the people who will have been put in control of your fate will understand what it was like at that desperate moment." Andrew is the author of The Law of Self-Defense, and his topic tonight is Stand Your Ground, the whole truth, the whole truth, and nothing but the truth. I bring you Andrew Branca.
Hey folks, before I start my, informal comments, I just want to say it's easy for all of us in this fight for our Second Amendment rights to come to think that we're only fighting feckless politicians, which of course we are. But hearing Vicky talk, it's important to remember what we're actually fighting is evil, right? Evil walking the earth among us. We want to make us defenseless against our enemies, make our families defenseless. It's important never to forget that. That's the true fight that we're fighting. Okay, those are my only serious comments for the evening. I'm not a very serious guy. I guess Paul mentioned it, but I'll rip the Band-Aid right off. I'm a lawyer. It's true. It's worse than that. I'm a Massachusetts lawyer. A Yankee in your midst. It's very interesting for me always to come from Massachusetts, and I've been a member of the gun community my entire life. I started competitive shooting as a young teenager and have been engaged in it all my life. To come from a place like Massachusetts where you basically don't mention guns like it's some kind of forbidden religious faith that's not allowed, and then to come to such a gun-friendly environment like this, it's almost like entering kind of a gun abuse recovery program. I feel like I should stand up and say, "My name's Andrew, and I'm a gun abuser. I love guns." It's true. It's true. I love them. I've loved them all my life. I love them for the fun, the pleasure they bring me in target shooting and competitive shooting, and I love what they can do for me in terms of being able to protect myself and protect my family, and of course what they mean in the more traditional perspective of our ability to resist the threat of tyranny. The importance of having the guns in the first place is that our possession prevents tyranny from taking root in the first place. Right? We need not have to bear arms against our government if our government fears us bearing arms against them, right? It's the deterrent effect that we want. And the deterrent only exists if we preserve and protect that right to keep and bear arms. Despite being a Massachusetts attorney, I consider myself a Second Amendment absolutist, by which I mean all prior restraint gun laws are on their face unconstitutional. Any mandatory permitting requirements, any FFL requirements, any class 2, 3, 4 requirements, any excise tax on firearms, anything, any prior restraint on the civilian ownership of small arms is unconstitutional on its face and should be recognized as such. And when the day comes, God willing, that the courts apply strict scrutiny to the thousands of gun laws we have to deal with today, they will fall like wheat before us. I guess I got serious again, didn't I? Okay, sorry about that. I have to say, if you had asked me 20 years ago, I got my concealed carry permit, started carrying a pistol for the first time in Massachusetts, of all places. If you had told me then that 20 years later I would be at a podium with folks like John Lott and Larry Pratt beside me, waiting to speak, I would have laughed. It would have been a ridiculous notion. It's so humbling to be here with them, these giants of the gun rights movement. These are the people who wrote the books I read 20 years ago that motivated me, even in Massachusetts, to become an activist in the gun rights community. They say every generation stands on the shoulders of giants who came before them, and these guys are it, and we ought to applaud them. And I think both of them, and including Paul, who's helped establish and found this amazing organization that you folks have, would be among the first to say that they can lead, but nothing happens without you guys, without all of you, and even little people like me, Massachusetts attorneys. But each of them still only has one vote. They can motivate, but they have to be able to motivate people who are willing to do the hard work that needs to be done to make the legislatures pass the laws they need to pass in order for our gun rights to be protected. And can I ask, who's the gentleman who's running for the appellate court? Could I ask you to stand up, sir? I want to make a point that may not be clear to many of you, but we work so hard to pass legislation that's favorable to gun owners. But it's important to recognize that legislative acts are really just the desires of the legislature. Where the rubber meets the road, where the effect of that legislation takes place is in the courts. And most importantly, in the Court of Appeals and the Supreme Courts of the states. And if we do not elect the people in those positions who are going to rule on those laws the way we need them to, you can pass all the legislation you want and it will have no effect. So it's very important. This gentleman and his peers, make sure you vote for them in these elections. Okay, I guess I'm supposed to talk about stand your ground. I'm already 45 minutes past my time. So I'll keep it as succinct as possible. There's a lot of misinformation about stand your ground. It's kind of, the phrase has become a boogeyman of the gun control activists. What we're really seeing here, by the way, is the opening of a new front against our gun rights. They've effectively stalemated, lost in the near term, the gun control movement. Of course, we can never give up. We always have to fight. They're kind of like a cancer. The moment you take your eye off them, they come back. But they've decided that they're not gaining much ground there, so they've turned away from controlling our ability to own, possess, and carry guns, and turning their attention to our ability to actually use those guns in self-defense. So now they're becoming less gun controlists in the near-term sense and more self-defense controlists. They're saying, okay, all right, we tried to take your guns away from you, didn't work. We tried to keep you from carrying guns, that didn't work. We tried to limit the places you could carry the gun, didn't work. All right, now what we're going to do is we're going to make sure that, all right, you can carry it, it's no problem, but if you ever use it, we are going to destroy you. We are going to destroy you economically, we're going to destroy you politically, and if we're lucky, we're going to get you sent to jail for the rest of your life. So one of the things that really upsets them is laws like stand your ground, because stand your ground makes it far more difficult for them to accomplish what they'd like to accomplish, which is to destroy us if we ever use guns in self-defense. Unfortunately, there's a lot of confusion about stand your ground, and they tend to use this phrase stand your ground to mean a lot of different things, because if they only use it to mean what it actually means, they'd get no support. I mean, let's face it, if these people didn't lie, they'd have nothing to say at all, right? So they take the phrase stand your ground and they lie about it. So let's talk a little bit about what stand your ground is, what it isn't, and why it's important, or whatever the formal title of my talk is. To understand stand your ground, you really have to understand what self-defense is in the first place, as a legal defense. So what you're essentially saying when you argue self-defense is, yes, I used force against another person, perhaps even deadly force against another person. But I was legally justified in doing that under the doctrine of self-defense. So how do you qualify for self-defense? You have to meet 5 elements of self-defense. Was anybody here at my seminar this afternoon? All right, you guys don't want to put your fingers in your ears because you've heard this 1,000 times already. But the 5 elements of self-defense are innocence, eminence, proportionality, avoidance, and reasonableness. So innocence means you can't have been the aggressor in the fight. Makes sense, right? The person who starts the fight can't claim self-defense to justify his use of force. Imminence means the threat that you're defending against has to be about to happen right now. Someone says, oh, I'm going to go home and get my gun and come back and shoot you. You can't shoot him right then. When he comes back with his gun, maybe you can shoot him, but not right then. The threat's in the future. Proportionality means you can't use more force than necessary to stop the threat against you. So if you're only faced with a non-deadly threat, you can only use non-deadly force to defend yourself. If you're faced with a deadly threat, you can use deadly force to defend yourself. It's not complicated. Avoidance means where you're in a jurisdiction or a situation where you have a legal duty to retreat, you have to take advantage of that safe avenue of retreat before you can act in self-defense. By the way, that's always been the minority position, and currently is by far the minority position in the U.S. The fifth element is reasonableness. Everything you do in acting in self-defense has to be that of a reasonable and prudent person, and you have to have actually yourself believed that it was necessary to act in self-defense. The 5 elements: innocence, eminence, proportionality, avoidance, and reasonableness. Not that complicated. What does stand your ground do? All stand your ground does is take away one of those elements, the avoidance element. You no longer need to seek an avenue of retreat before you can act in self-defense. What's left in place? Everything else. Innocence, eminence, proportionality, and reasonableness are all still in place. Stand your ground is not some parallel or bizarre way of claiming self-defense. It's not some mysterious mechanism the NRA put in place. Stand your ground of self-defense is exactly the same as the old-fashioned self-defense, except for that one element of avoidance. So if you live in a stand your ground jurisdiction and you act in self-defense, what do you still need to be able to prove? You were the innocent person, you were facing an imminent threat, you used no more force than necessary to defend yourself, and everything you did was reasonable. The non-stand your ground states, what they say is, even if you've done all that, if you can't prove a negative, if you can't prove that there was no safe avenue of retreat, we reserve the option to put you in jail for the rest of your life. That's what living in a non-stand your ground state means. So thank God you live in a stand your ground state here in North Carolina. Now, think about what the consequences would be of a repeal of stand your ground. Imagine a young woman named Mary. She's walking through a parking garage at night. She's accosted by a rapist. She's done nothing to invite this attack upon her. The attack's about to happen right now. And drawing her gun, she uses no more force than she needs to defend herself against the rapist twice her size. And her perceptions and her conduct throughout were entirely reasonable. But the prosecution in a non-stand your ground state is free to argue that there was a stairwell over there, and Mary could have run away rather than defend herself against that rapist. In a non-stand your ground state, she goes to jail for the rest of her life for having defended herself. In a stand your ground state, that question doesn't even come up in trial. That's why stand your ground is important.